Namaste. Welcome to the YouTube channel Analytica Ayurveda. And of course, we are discussing here on every Monday the Drug and Cosmetic Act 1940 and the Drug Rules 1945. Of course, this is the case when everyone is having a very good interest into the drug rules. Every corner of the society, they are interesting to know about what are the phenomena here going on for the Ayurvedic drugs. Okay, we will take it in this way or that way. Just before starting the recording of this channel, I got a call from a very renowned family of the Banaras, and they want to start some startup and produce Ayurvedic hair oil, and in this relation they want my consultation what to do and how to do, because they are producing till all that hair oil for the family, but now they want to propagate it into the business. So what is my submission? That days are for the entrepreneurship, days are for startup, and days are for the strict following of the rule regulations concerned to that your project. You see, a day before yesterday, the news was circulating in all over country that the then DGCI, because the RTI has revealed that about the abundance of the Rule 170 of the Drug Rules 1940, in which the misleading rules about the misleading advertisements are being withdrawn by the Ministry of Ayush. But one RTI activist demanded the whole procedure, and it has been revealed, and that has been published right from the Statesman to the Guardian to the many more newspapers up to date, that the then DGCI, Dr. V. Somani, objected this withdrawal, and it is a really going to create a lot of administrative hiccup, because once DGCI is objecting that no, this rule should not be withdrawn, or you amend the DMR 1944 in which the Ayurvedic drugs must be included and stay it for the 1 year, it's matters. But the situation is like this. Okay, your note of dissent or your consent or your anything else is having very less worthiness before the agendas which anyone want to be get passed. And when the Ayurvedic manufacturers are of the opinion that this advertisement act, specifically the misleading advertisement rule, must be withdrawn, I don't know why they are in the favor to withdraw it. If you are doing ethical business, then what is the need of what is the need there for the any misleading advertisement under the definitions of the advertisement? Many companies are existing in the market more than 100 years by their ethical practice. Why not you? So, okay, this is the just preamble ki what is the importance of the rules, and we have discussing nowadays Rule 160. And today, after completing the Rule 16D, today is the term of Rule 16E. So, kindly dear friends, open the book, because without opening the book, nothing is possible in the interaction of the rule and regulations. So here we are going through the Rule 160, which is mainly for the establishment of the drug testing laboratories, DTL, specifically the licensing of the DTL, and any report of the DTL may be used to get the license or for the export purpose as per the case. So how a DTL may be established, and what are the part of the DTL, and what are the 6 components of the DTL, and what are the equipments required into the getting a license for the DTL, all we have discussed. We have discussed about what are the things required for the chemistry section, pharmacognosy section, Ayurveda section, and many more. So now we are discussing about the inspection before grant of approval, and that is the rule 160E. So read it. Before an approval in Form 48 is granted, the approving authority shall cause the laboratory at which the testing of Ayurveda, Siddha, Unani drug, as the case may be, is proposed to be carried out to be inspected jointly by the inspectors appointed or designated by the central government and the state government for this purpose, who shall examine the premises and the equipments intended to be used for testing of drug and verify into the professional qualifications of the expert staff who are or may be employed by the laboratory. What is special here? Very special. And that special is, my dear friends, joint inspection by one nominee of the central government and one nominee of the state government, in which that DTL is existing. For the licensing, this joint inspection is not required. For the manufacturing unit, this joint inspection is not required. Just the state is sufficient. But here in this case of the drug testing laboratory, before the approval, the joint inspection is required. One inspector representing the central government, and here the central government means Ministry of Ayush, and the state government means that particular state and the person deputed by that. And they will examine the three things there. What are those three things? What we have discussed. The staff, the professional qualification of the staff appointed there, which we have discussed. A BMS must be, or a BSc Botany, or a BSc Chemistry, but it should be enhanced, because the simple BSc Chemistry or the simple BSc Botany for the pharmacognosy, when we have the availability of the M-Pharma Ayurved quality control, when we have the M-Pharma Ayurved pharmacognosy, when we have the M-Pharma Ayurved Dravya Guna, they should be given the opportunity. If you have the MD Ayurved Rasastra and the Bhashaj Kalpana, if we have the MD Ayurved Dravya Guna, why not these people be given priority on the plain graduate level? Everywhere you want expert, but in the law you are showing the minimum qualifications or a lot of alternatives which are being misused by the companies, because these graduates are available abundantly. You can hire them under the underemployment situation, a very less pay. But if you go to this postgraduate and having some expertise in the quality control required for the DTL or for the required for the analysis of any Ayurveda drugs and maybe worthy for the DTL, I want to say this, certainly they will demand a higher package. And if you want your company to proliferate, to progress, and your licensing should be without any suspicion, and that may be used for even for the export of the drug, Ayurvedic drugs, then certainly these highly qualified people must be there. MD Ayurved Rasastra and Bhashaj Kalpana, because they are well qualified as per their present curriculum to perform the any analytical test, as well as the same MD Ayurved Dravya Guna. And of course, the M-Pharma Ayurved quality control and the M-Pharma Ayurved pharmacognosy, they are the qualified persons which are available. So this should be in this way that see, when you are doing a good job, must be there a phone call. And if you are sitting, there will be no phone call. Huh? So it happens, oftenly it happens. Fine. So this is about the rule 160E, and the important point is the joint inspection, the professional staff, the machinery there, and they will examine the premises. The three things. The premises, it's all location and everything as per the law, the equipments there as per the requirement notified, and of course the professional qualifications. Now come to the 160F. Then 160F, it is the report of inspection. The inspector appointed by the central government as stated in Rule 160E shall forward to the approving authority and detailed report of the result of the inspection. Yes. See, here it is very clear. The license will be issued by the state authority. So, this report of the inspection by the nominee of the central government as well as the state government will submit it to the inspector appointed by the central government as stated in Rule 160E shall forward to the approving authority a detailed report of the result of the inspection. Means very clear. Who is boss? Boss is the authority of the central government, not the state government. And that boss will submit the report to the approving authority. Now 160G, procedures for the approving authority. If the approving authority, after such further inquiry, if any, as it may consider necessary, is satisfied that the requirement of the rules made under the Act have been complied, and with that the conditions of the approval and the rules made under the Act have been observed, it shall grant approval in Form 48. Matlab, otherwise meaning the inspection and the questions, the queries, and after the satisfaction of the question and the queries, if any, there must be, and after full satisfaction with the premises, equipments available, and the qualification of the professional staff, not on the only degree, but in the practicality too, because previously we have studied they may ask to perform the test to the person who has been appointed. So it is not like that on paper, the ghost teacher. Now it is not possible in the NCSM also. The only the person is giving a certificate that I am basic chemistry and so I am qualified to do all the analytical test. No, not at all. Inspection committee may ask the person to perform the test, analytical test, before the committee. So after that, it will be satisfying everywhere. Then it will be issued on the Form 48 that this organization may work as a drug testing laboratory, and certificates issued by this for analytical certificates issued by this company may be utilized for the said purpose, mostly for the license approval of the licensing or for the export. So the clause 2 is if the approving authority is not so satisfied, it shall reject the application and shall inform the applicant of the reason for such rejection and of the conditions which shall be satisfied before approval could be granted. दूसरा रास्ता, दूसरी स्थिति, दो स्थितियां हैं, या तो आपका स्वीकृत हो जाएगा या आपका अस्वीकृत हो जाएगा. So in case if it is being rejected, then the reasons must be quoted there. What is the reasons? Yes, your professional qualified staff is not competent. The staff there is not matching with the professional qualification laid down in the Act. Or there is very less machinery, this machinery is not there and so you can't perform the analytical test of the Ayurveda. Or the premises is very short or nothing there and the condition and the ventilation, all these things are not up to mark. So the rejection is there. So if anything if any condition is prevailing for the rejection, that must be informed to the applicant in the writing. Then the next step is application after rejection, that is the 160H. If within a period of 6 months from the rejection of an application for approval, the applicant informed the approving authority that the conditions laid down have been satisfied and deposits inspection fee of 2000 rupees, the approving authority may, if after causing a further inspection to be made and after being satisfied that the conditions for the grant of approval have been complied, with the grant of approval in the form 48. अब यहाँ देखिए 16H क्या कहता है कि एक बार अगर आपका रिजेक्शन हो गया, then within 6 months you may apply, informing the approval authority that all the queries has been complied, and you have to pay additional 2,000 rupees to the government for the re-inspection. But here Chakrapani is mon. What I mean to say, that in this re-inspection, whether the nominee of the central government will be there or not, or the only state government nominee will inspect. But it may be considered here, if it is not written, then it should be presumed here that the inspection will be in the same gravity which was done earlier. So earlier it was inspected, premises was inspected by the central government and the state government jointly. So after the rejection also, because the government, this report is being submitted by the boss, that is the central government. So the re-inspection must be with the central government. It is not written, but it should be presumed that the representative of the central government must be there into the re-inspection of that particular company. So the central government and the state government both. So this is the all for today, and we will continue the rule 160 for the next issue also, and then I think one interaction is required here more, and then we will complete the 160, and then certainly we are going to start a very interesting title, that is the part 17th, labeling, packing and the limit of alcohol in Ayurvedic, including Siddha and Unani drugs. But before coming to the rule 161, we have to go through the rule 160 IJK. That will be on the next, that is on the next Monday. You will be able to hear it. It may be, that is the 13th November, but it may be the 21st, 20th November. 20th November, of course. 20th November. It is a very important date of my life, because on this date I was selected at Gujarat University, Jamnagar in the IPGTR as a lecturer. 20th November 1999 was the interview date in which we 3-4 lecturers were selected there. Just the dates are important, and it should be important in your mind too if it is related to your personal achievements. Anyhow, friends, so we will discuss the 16JIJK on the next, and today we have discussed 160EFGH. So this is all about the inspection and the rejection, and the important point is that is the joint inspection. If rejected, re-inspection, then also it should be joint. Okay, and after the rejection, the re-inspection, a fee of 2,000, of course, and then the form 48. Renewal will be in the form 49, but that we will be discussing into our next interaction. Kindly go through the whole spirit of the rule 160, and that is the insurance of the quality of the Ayurvedic drugs, and what is going on, that we are recording it on the 6th November. And if you see all the dhamaka done by the RTI activist Mr. Babu, and he got the official procedures list of the proceedings of the DGCI into the meetings of the ASUD tab, it is very clearly indicating what is the gravity and how the pressures are on. Of course, pressures must be, but the pressures for the production of the good quality drugs. Pressure must be there for the propagation of the Ayurvedic medicine on the virtue of its quality, safety and efficacy. Not those kind of the pressure where there are the compromises into the standard of the Ayurvedic medicines or the there something on the compromises on the way of the advertisements there. So it is up to you in which way we are going. Thank you. Meeting again with the rule 160 continuation. Namaste.